is a permission to appeal in the Claimant application of Al-Haq and Secretary of State for the Business and Trade.
Good morning, ladies and Lord. If the court will indulge me, I'm not going to introduce the mass of barristers. I hope that the court has a list.
We have got a list. We weren't sure how many of you were coming, but it looks like lots.
Not all, but lots. I appear, as the court will have seen, on behalf of Al-Haq, and there are three of us this morning who are going to make submissions on our client's behalf. So that's myself, Mr. Steyn, and then Mr. Moore.
Yep.
And I just want to outline for the court how we're going to divide that up, so you know where we go. And it doesn't all follow in an order, but it makes sense so that we're not all popping up and down, and to us, but so we don't all pop up and down 4,000 times. So
Certainly.
I'm going to deal with ground one in respect of one of the three reasons that the divisional court held that the ground our challenge to ground 8 was not justiciable.
Which reason are you dealing with?
I'm going to deal with the non-justiciability on grounds of national security, defence and safety.
So the first reason.
The first reason. Then Mr. Hussain, but he's not going to do so straight away, will deal with the last two reasons.
Okay.
But before he does that, Mr. Moore is going to address you on ground 5 and some points that arise in relation to ground 2, namely in respect of the certainty of the content of the CIL obligations. Mr. Hussain is then going to address the court on those two aspects of ground 1 and ground 2, and then finally I will address the court on the reopening application under CPR 5320. 5230.
Yeah.
5230. So that is ground 1 aspect of ground 3. So can I just remind the court that ground 1 is directed at what was ground 8 in the court below and the divisional court's conclusions on that. So the defendant's published policy, the strategic export licensing criteria, and I'm not going to take the court to them, constituted guidance issued pursuant to statute. And by criteria 1 of that guidance, the Secretary of State was required not to grant a licence if to do so would be inconsistent with the United Kingdom's own international obligations and commitments under various instruments. And the basis of the challenge in ground 8 that Al-Haq brought was that the F-35 carve-out was not inconsistent. And it was argued that the Secretary of State had misdirected himself as to the scope and effect of 3 international obligations that cast obligations on the United Kingdom. That's Common Article 1 of the Geneva Conventions, Article 6 and 7 of the Arms Trade Treaty, and the duty to prevent genocide under Article 1 of the Genocide Convention. And the court held in respect of that entire ground of challenge that it was non-justiciable. And if we can turn to that judgment where it starts to address the first ground that I'm going to deal with. So that's in Core Authorities, tab 7, page 98. Sorry, yes, page 98. So actually 97 is where it's appropriate for the court to start. And if the court can just, to remind yourselves, read paragraphs 110 to 112. And note the heading, do the strategic export licensing criteria provide a domestic foothold? So that's the question it's asking itself. So step one is paragraph 110, and that's an important step in their reasoning, because the court is saying, so far as the domestic foothold of there being some lists in domestic law, some asserted right in private law or duty in public law that gives rise to the obligation on this court to look at questions of international law, so far as that is concerned, they could see that the statutory guidance, that is, guidance issued pursuant to statute, provided that foothold into domestic law, that everything else being equal would open up the opportunity for the court to exercise its jurisdiction to look at and address issues of the interpretation and application of international law. That's step one, but step two at paragraph 112 is to say, well, no, actually, there is in fact no domestic law foothold, and that is because that the decision in question, which the court said was centrally concerned with the UK's interests, national, international security interests and defence interests, was one that is reserved under our constitution to the judgment of the executive, which is democratically accountable to Parliament and the electorate, and it's not for a domestic court to decide. So that is a non-justiciability basis, quite separate from domestic foothold in the sense I've just described it, but which is articulated as a domestic foothold point. We're going to have to go back into that judgment, and I know we've got not much time, but it's complicated stuff, and we will have to try and see how the court reasoned to that. But before we do that, I'd like to go...
just to reassure you, we've all read extensively into the papers because we were very conscious there's a lot to get through.
Well, I'm very grateful. And can I just at this point also ask, because I think we know a little bit of a problem at our end, did the court get sideline bundles of authorities? Red for the claimant and blue for the court.
Electronically,
Yes.
mine was sidelined.
Yours was sidelined electronically.
Mine don't look red sidelined.
No, that's the problem. They were sidelined electronically, and then when the printing
I was
happened,
looking at mine electronically as well, which is why there's no...
Hard copies, volumes 2 and 3 are sidelined.
okay, hard copies of volumes 2 and 3 are, which is strange. So we might find that they are, but if the court's
They'll
looking at them
manage, don't worry.
hopefully, and you can follow the reading list. Hopefully,
Exactly, we had the benefit of the reading list, so don't...
Perfect. Well, that will speed us along greatly. So before we do look at that reasoning, I do want to take the court through the authorities relating to foreign act of state and the authorities, well, I'm not going to focus a great deal on the authorities on national security because the court is well familiar with them. But the reason for doing that is because you will have seen our case is that the divisional court applied a basis of non-justiciability, the one we just looked at, that simply doesn't exist. And the sole basis of non-justiciability, where cases concern matters of foreign relations, whether or not also giving rise to interests of international security, national security, defence, and so forth, and whether on grounds of comity, whether on grounds of democratic accountability, institutional competence, is by the application of the Foreign Act of State doctrine. And then, once that jurisdictional gateway has been entered, if it has, that is, it is established that the Foreign Act of State doctrine either doesn't apply or the case falls within its exceptions, that doesn't mean the court then exercises a full-throated judicial review jurisdiction. It will accord deference, and that's the national security cases of Raymond and so forth. So we need to look at that in order to then understand how it was that the divisional court went wrong in suddenly finding this entirely separate, very, very, very broad principle of non-justiciability, which appears to admit of no exceptions. So Al-Haq is the key case. I did give the court a lot of references to Al-Haq. We'll go through some of this just quite quickly because what I'd like the court to see is the cases that were considered in Al-Haq when it looked at this, it has to be said, at the time that the matter came to the Supreme Court, an incredibly messy doctrine so far as the court's understanding of its contours, its rationale and so forth were concerned. By the time the court would have seen the observations that have been made by academics in relation to it. And this was the opportunity for the court to grapple with this doctrine and try to understand what the underlying rationale was and to identify its proper contours and its exceptions. So this is the leading authority, and the majority judgment is Neuberger's judgment. So it's at Authority 17, page 602. I'm going to start with Lord Neuberger, but we will look a little bit at Lord Mance and Lord Sumption. So, can we turn to paragraph 117 on page 749? So he's just dealt with state immunity, and he turns at 117 to the Foreign Act of State doctrine, which he identifies immediately as raising more troubling issues. And you'll have seen from the two incredibly lengthy judgments by Lord Mance and Lord Sumption that there was still much disagreement about the actual parameters of the doctrine. But if you can read quickly through 118 to 119. Note 119, it's really important. It's an important observation about what went on in relation to the previous authorities. The courts didn't know and hadn't identified that they were in fact dealing with Foreign Act of State. He then goes on at 120 and to 121 to deal with the first two doctrines, and then at 123 comes on to the third rule, which is the Foreign Act of State doctrine operating on the international plane. And if the court can read paragraph 123. So he's identified a possible basis for it, only really appropriate for diplomatic or similar channels. And note, it's about determining the legality of the foreign state's actions. It's not a situation concerned simply with making observations as a matter of fact about how a foreign state has acted. That happens, for example, in relation to asylum cases all the time. The court is making very, very damning factual observations. It's about determining the legality. And then 124, a possible fourth rule, which is very much doubted, and we'll see that further again. Fourth rule is about the courts embarking upon a process of determination which will embarrass the government, and that is very much doubted. And you can see that you need a communication from the Foreign Office. Nothing like that ever happened in this case, so we're not dealing with the fourth rule here. So then, from there, if the court can move to 129 to 130. Just note, two cases there, Boots Gas, Kuwait Airways. Recognise the court's looked at this already. Boots Gas, Kuwait Airways, two cases considered under the third rule of the Foreign Act of State doctrine. And then 130, if the court can read this paragraph in full. Both those cases, and note, Campaign, the CND case, and Norcan are identified in this majority judgment as instances of the application of the third rule of the Foreign Act of State doctrine. And at 144, page 755, note the caution that Lord Neuberger states must be applied in imposing the rule. And whatever he says about private law applies equally to a public law claim. One 147 talks about the difficulties between the barriers between the two rules, and then identifies the sort of situations in which the third rule will apply. And he's talking about relatively high level actions of a sovereign state, whether they are in relation to another sovereign state or not. And then at 151, another statement in relation to what the possible rationale is. Based on judicial restraint, it applies to issues which judges decide they should abstain from resolving, as discussed by Lord Mance and Lord Sumption. It's purely a common law rule. Then he moves to discuss the limitations and exceptions. And if we can just look at 153 to 157 very quickly, because we're not actually dealing with the policy at the moment, but it's important because you will see, and you'll see this also in relation to Lord Sumption's speech, that the policy, the exceptions, the public policy exception focuses on grave violations of international law, peremptory norms of international law. So if the Foreign Act of State doctrine is applicable, then one of the reasons, in principle, one of the reasons to disapply it is that what the court is being asked to look at are grave violations of peremptory norms, i.e. the doctrine does not prevent the court, when properly engaged, from looking at breaches of international law where they are so grave as to constitute violations of peremptory norms still, and so forth. So we can see that, for example, at 168, I would, having said that, even if, so his position, Lord Neuberger's, was the doctrine itself is relatively narrow. It only covers very, very high level interstate activities. But he said, goes on to say, if I'm wrong about that, then the public policy exception would apply. And he says, E to F, in that connection, Lord Sumption's impressive analysis of the relevant international law is important in the present context because I consider that any treatment that amounts to a breach of jus cogens or peremptory norms would almost always fall within the public policy exception. And that is precisely the same approach that was taken by Lord Sumption. Can we then go back into the judgment of Lord Mance? And here it's really to look at the underlying rationale for the doctrine, together with the sorts of cases that the court was presented with and looked at in the course of the hearing and were considered. So if we start at paragraph 32, page 709. First 4 lines. The starting point of the appellant's case is that adjudication of the issues now before the court in favour of the claimants would necessarily involve a finding by the English courts that foreign states had acted illegally under the laws of the places where their conduct complained of occurred. So that is a critical threshold condition. If you're simply complaining about the actions of a foreign state, whether in the most critical terms, whether painting their conduct as heinous as is possible, if you are not actually requiring the court to determine the legality of that, the Foreign Act of State doctrine simply isn't engaged, and there's nothing to prevent the court from entering upon that adjudicative exercise, as it does in asylum cases, etc., all the time. And then we have the quote from F.A. Mann on the difficulties with this doctrine. And then if we move to paragraph 37, you can see as we move through, there's UCOS that is considered. And then we have three types of Foreign Act of State at 35. It has to be said that the court was not in agreement about all of this. But you look at the cases that he moves through, down to 37, we get Oppenheimer and Kuwait Airways. And then at 46, so moving down, and if you just cast your eye as we go down, Buttes Gas and UCOS, Buttes Gas again at 42. There's consideration of the Shergill and Kyra case, the ancient case of the Nabod of Karnataka, and then we get H.J. Rayner. And finally, at 46, he starts a further analysis of the case law. And he looks at the United States cases at 47. We've got Underhill again. Sorry, not again. It's the first time he's mentioned Underhill. And this is all being looked at as instances of Foreign Act of State cases. And we go on through 57 Buttes Gas, and finally then if we could go to paragraph 85, the application, 85 page 736, and we get to the application of the third type of Foreign Act of State. We'll just read that. You can see the possible foundational principles for here: separation of powers, sovereign nature of interstate activities, comity. And then if we turn from Lord Mance to the judgment of Lord Sumption, which starts at page 761. On the facts, we can see at paragraphs 237 and 238. He would have held that the Foreign Act of State doctrine did apply because he cast this doctrine in a far narrower, in a far broader way.
Are you?
Sorry, this is 23728, page 790. So he says it applies, but he would then have disapplied it on public policy grounds. But importantly for us, what I want to address with the court is the rationales that he then considers and the cases that he also looks at. So if we can go back to 785, and paragraphs 225 to 227, if I can ask the court to read, I'm very aware that we've not got much time, which is why I asked the court to hopefully read this beforehand. So what we can see in this passage, again, identifying two possible bases, comity, separation of powers, and then importantly distinguishing cases that are really about the absence of a domestic foothold. And there he identifies Al-Haq and the CND cases as cases of that nature. And by domestic foothold, I don't mean the sense in which the divisional court meant it, I mean the sense in which there is no domestic law, right or duty that enables the court to entertain the interpretation or application of international law. And then if we look at 234, again, international law act of state, that's what he calls the third type of act of state. Again, he's making the point that it is absolutely only engaged when the courts are required to adjudicate on the lawfulness of the extraterritorial act of a foreign state. 2, 3, as we move through, again, looking at the authorities that he is considering, and then we get to 237, if the court can just quickly read that. So we see the sorts of acts that engage the doctrine. All these acts of a military defence of the realm nature. And then 239 to 42, the juridical basis. If I can just quickly summarise what he's trying to distinguish here, he's trying to distinguish a situation where there are no manageable standards that exist at all, i.e. the arena is not even one in which law itself enters the terrain. So pure power politics would be an example, or the conduct of Parliament would be another example. Matters where the law simply does not enter. Then there are situations where the conduct of the state is incidental, i.e. you're not having to determine the legality of that state's conduct. So those are the examples I gave about asylum cases and so forth. And this is all important for Mr. Samora and ground 5. And then 248 to 255, very quickly, if the court again just looks through, you'll see the cases that were considered in Belhard again. And importantly, what this analysis shows is the changes in international law and also the change in the approach of the courts since some of the cases were decided. So the no-go territories in the past were not no-go territories now. I'm afraid we haven't got time to actually go through all of this. Can I then move on to the subsequent cases? There were 2 subsequent cases in the Supreme Court, Madura and the Law Debenture Trust. Now, I can give the court references and Sir James can contradict me, but those cases were foreign act of state cases. They were cases where the court looked at the question of non-justiciability by reference to foreign act of state. If the court wants at the end, I can come back and give you the references, but we don't have time to.
Just tell us where they are in the
Yes.
authorities bundle, would you?
Okay, so Majura is core authorities 27, and Law Debenture Trust is core authorities 31.
Thank you.
And then the second area that I wanted to address with the court before coming on to look at the divisional court's judgment was national security cases. And the court will be well familiar with Raymond and the cases that have followed. The only case I need to take the court to is Campbell, which is at Authorities 36, because it provides a very helpful, quick summary of where the law is in relation to issues that engage national security that come before the court, where the Secretary of State has made an assessment of national security. And that's at paragraphs 44, page 1741, 44 and 46. So you don't gainsay the assessment that Secretary of State makes as to what is in the state's national security interest, but there's no reason why the court cannot determine whether the manner in which, for example, in this case, the defendant has gone about attempting, having identified one national security interest, there is no reason why the court cannot at the same time ask whether or not, in relation to an exercise he's compelled to undertake where that assessment of the national security interest is relevant, he's nonetheless gone wrong in other aspects, which then impacts potentially upon the overall balance, for example, that he strikes, or impacts because he's failed to take properly into account something that weighs against the national security interest. And that is this case. So going back to the Divisional Court's judgment, and that is in the Court Permission Bundle at tab 7, paragraph 72, page 76. What the court does there is it looks at the basic rule of non-justiciability at paragraph 72, and through 72 down to 77, the court is looking at the rule of non-justiciability, which is really the flip side of the domestic foothold point, i.e., this is our dualist system. International law does not form part of domestic law, so any international law issue that is brought before the court simpliciter will be non-justiciable. So that's step one. No argument about that. The court then goes on at paragraph 78 to consider another matter which it says provides a distinct basis of non-justiciability, namely matters concerning the conduct of foreign affairs, because domestic courts should not normally determine issues that are really appropriate for diplomatic or similar channels. So we saw that in 1112, and this is the first mention of it we get in the judgment before 1112.
So it's 78.
78.
Yeah.
And we see there is a reference to Belhage, there's a reference to Maduro. Both of those are foreign act of state cases. Then there is a reference to Jones. And if the court can read Jones, and the passage cited from Lord Bingham's judgment, judgment in 2006 before the Al-Haq case, you can see all the authorities they're relied on are either J.H. Rayner dualist system or they're foreign act of state. So they identify this, for the first time, this rule of non-justiciability by reference to what are foreign act of state cases and issues.
So can I just summarise your proposition? You say that the divisional court went wrong because it invented a new rule of sort of constitutional inappropriateness, which you say doesn't fit with existing case law at all. Is that
Yes.
what it is?
So there are rules of constitutional inappropriateness. Foreign act of state is one of those. It rests upon some of the same notions that the court there identified. It rests upon separation of powers, the constitutional rule of the separation of powers. This is for the executive to deal with foreign relations, to deal with defence and security and so forth. So the foreign act of state doctrine does have that as one of its foundations, but it is that rule which was the foundation for the cases that Lord Bingham is looking at when he makes the speech he does in Jones. And the divisional court doesn't recognise that. It treats this caution as being something different to foreign act of state, or this rule of non-justiciability and basis. So, and it's very important to note that the divisional court doesn't identify this. It doesn't recognise that these are all foreign act of state cases considered by the Supreme Court in Al-Haq. So it then went on to consider the national security and democratic accountability cases, which we've just looked at. And it makes this connection at paragraph 82. The national security cases it's looked at. So those are cases where the court has jurisdiction but exercises deference. And then at 82 goes on to say these principles were applied in Al-Haq, an earlier divisional court case involving the present claimant. And it cites paragraph 46 from Lord Justice Pill's judgment. So the first step is cases about deference were relied upon in Al-Haq as a basis for non-justiciability. When we look at it, we'll see that that's simply wrong. Deference is deference, non-justiciability is non-justiciability. So we're going to have to look at Al-Haq to see.
Al-Haq 1.
Al-Haq 1, yes. Sorry, we're Al-Haq 2, so we'll look at Al-Haq 1. So that is in the authorities, 12, at page 350. If we start with paragraph 1, this is a permission decision. It's important to note. So, if one looks at paragraph 1, one can see what was being sought. So one can see immediately from paragraph 1 that this is a challenge that is bound to fail because of our dualist system, i.e. there is no domestic foothold. It's not alleged that there is some illegality as a matter of domestic law perpetrated by the defendant which requires a determination of the international law obligation. The claimant is going straight to the court and just saying, make a declaration about the international law obligation. So that's, and we'll see, that's the basis upon which the case was refused. So anything else that is said in a permission decision is overturned. So if we go through, we can see at paragraph 25 what is put forward as the domestic legal basis of the claim. And then we can see the government's arguments at paragraphs 28 to 30, and we can see they are relying upon foreign active state cases, Utes Gas, Kuwait, CND, Abbasi. And then, if we turn to paragraph 41, court reads that quickly. So, again, you can see this is all about foreign act of state. And that culminates in the analysis of paragraph 46 that we just saw quoted in the judgment of the Divisional Court. But before we get there, paragraphs 44 and 45 make it quite clear that the basis on which the court decides that the claim has to be dismissed at a permission stage is no domestic foothold. There is simply no legal issue that the court is capable of determining given the dualist system.
46.
Sorry?
46.
Yeah, we did look at 46. That was quoted in the Divisional Court's judgment. My point being, in relation to 46, what has led the court to cite 46 is precisely what I've just taken the court through, which is an analysis based on foreign act of state. And 46 is cited in the Divisional Court's judgment of paragraph 82. So that's Al-Haq, which is again a foreign act of state case, a permission decision, and a decision which was decided. So at the very most, it's obiter. Secondly, it's in any event a foreign act of state decision. So if we return then to the Divisional Court's judgment, at paragraph 83, the Divisional Court deals with domestic foothold in the sense that I've been using it. We don't need to look at that because we saw paragraph 1110. That point is argued. And then it goes to non-justiciability and deference. Paragraph 88 to 90. And if the court can read these passages, 88 to 90. So, number of mistakes there. The first mistake that the court makes is it's identified two entirely different principles and treated them as similar, which has led to the conclusion that there is somehow a spectrum from deference to non-justiciability. But the non-justiciability matter that it considered is there is no domestic foothold. i.e. there is simply no way in. Deference, which is premised upon there being justiciability, it's an either or situation, is founded on an entirely different set of reasons.
Can I just ask you, sorry to interrupt, paragraph 89, the second subparagraph of Lord Justice Simon Brown's summary,
Yes.
is that fair to characterise that as either act of state?
That's foreign act of state. And that is foreign act of state that because we know it is,
Yeah.
because it has been most authoritatively described as that at paragraph 130 of Lord Neuberger's judgment in Belhage. That is an expression of what has later been grappled with and understood to be foreign act of state. So finally, we see from this, we can then move back to paragraphs 1110 to 112, and we see how they got there, and we can more clearly see why they have gone awry at paragraph 112, and why, for the purposes of this hearing, at the very least, it is arguable that the divisional court went awry. So going back to 112, under the heading on page 97, do the strategic export licensing criteria provide a domestic foothold, i.e. we're looking at this as a foothold issue, not therefore as a foreign act of state issue or anything else. And they have treated at 112, firstly, the existence of this rule of non-justiciability as a foothold issue, which is entirely wrong. It's totally different to there being no issue between the parties that the court can properly grapple with that requires the application of international law. But secondly, they have identified a principle of non-justiciability whose contours are entirely unarticulated, of which it apparently admits of no exceptions, that is in fact nothing other than the foreign act of state doctrine, which they themselves then at paragraph 122 decide they don't need to apply at all because they've knocked the case out already on the basis of this distinct basis of non-justiciability. So unless I can help you further, those are my submissions on the first ground.
Thank you very much.
My ladies, my lord, I will address the court this morning on two aspects of the Divisional Court's judgment. The first is the Divisional Court's conclusion that ground 8 of the claimant's claim required the court to adjudicate upon the lawfulness of the conduct of Israel. This is ground 5 of the claimant's appeal, but it's also relevant for the reasons that Kaufman has just indicated more broadly to ground 1. The second aspect of the Divisional Court's judgment is its conclusions that the customary international law rules relied upon by the claimant for the purpose of ground 8 of its claim are so unclear as to be inappropriate for reception into the common law. The claimant challenges those conclusions of the ground 2 of its appeal.
I thought it was ground 9 below.
Ground 9, that's apologies. No respect. Subject, of course, to any questions from the court, I propose to take the issues in that order. So in relation to ground 5, if I may begin with the relevant passages of the judgments, core bundle, tab 7, page 99, paragraphs 121 to 122. So here the Divisional Court recording the submission of the Secretary of State, Neuberger's third rule applies because the claimant's claim involves a challenge to the lawfulness of the conduct of the State of Israel. It's to the claimant's response summarised by the divisional court. First point, it's not the lawfulness of the conduct of Israel, which is engaged or raised by ground 8, but rather the lawfulness of the conduct of the United Kingdom. In paragraph 122, the divisional court rejects that submission, says that the lawfulness of the conduct of Israel is at the heart of the claimant's claim. And we say with respect to the divisional court, that misunderstands the nature of the claim that was advanced under ground 8. And to make good that point, I'll address the court on 3 issues. So first I'll address the court briefly on the 3 relevant rules of international law pursued by the claimant below, which are maintained on this appeal, and explain how those claims did not require any determination or adjudication as to the lawfulness or unlawfulness of any act by Israel. Secondly, I'll explain, or rather address, an alternative case that was advanced below, which is not addressed in the court's judgment, which on any view does not fall foul should not be subject to the criticism made by the divisional court. And thirdly, I'll deal with footnote 10 of the divisional court's judgment, which the divisional court relies in paragraph 122 of that judgment. Returning then to the specific rules, Ms. Kaufman has indicated the 3. The first, Common Article 1 of the Geneva Conventions, as the court will know, this is an obligation that appears in all 4 of the Geneva Conventions that requires the high contracting parties to respect and ensure respect for those conventions. The claimant's argument below is summarised as follows, which is that the UK could not act consistently with that duty whilst exporting weapons to a state which the United Kingdom had assessed was not committed to complying with international humanitarian law and thus the Geneva Conventions, and where the United Kingdom had assessed that the weapons that were being exported were at clear risk of being used by the receiving state to commit or facilitate serious violations of humanitarian law. You can see that as the case that was advanced if you look at the amended statement of facts and ground, which is in the core bundle, tab 11, page 509.
Wants to turn that off?
Please, my lady. Yes.
Core bundle 509.
Lord, yes.
Thank you.
The relevant heading is page 4508, the ground 8, first point, incompatibility with the UK's international obligations to respect and ensure respect. Paragraph 204, which reads that. Perhaps the court could read down to paragraph 205. See that this is the claimant's case with regard to the respect aspect of Common Article 1, so the duty to respect the Geneva Conventions. And the case that's put there is a case that's based on risk and risk assessment. It said that the assessment that the Secretary of State has made is one which renders the continued export of arms to Israel inconsistent with the United Kingdom's duty to respect the Geneva Conventions. So that's the case that's put. Go over to paragraph 209. You can see the case that was put in relation to the ensure respect duty. I'll come back to this distinction when dealing with the nature of the customary international law duties, but for now it's sufficient just for the court to note the way that the case was advanced. So I've asked the court to read paragraph 209. The case that's being advanced is based on assessment of risk. It is not one which is based on the necessity of any finding by the court, or in one which invites the court to make any finding in relation to the conduct of Israel, less still the lawfulness of any act by Israel. But the passages I've just directed the court to cite the ICJ's judgment of Nicaragua and the United States. If I may just take the court briefly to that case, just so the court can see and understand the origin of this point and where the claimant takes us from. So it's in the Authorities Bundle, tab 40, starts at page 1805. These are not authorities that we thought it necessary to burden the court with on their already quite long essential reading list. So if I may just take the court through these passages now.
I'm very grateful you didn't add them to the reading list. So, tab 40.
Tab 40, Melody. The first passage, invite the court to read is page 1808, paragraph 219. The case about US involvement and support for a group called the Contras in the course of a non-international armed conflict in Nicaragua. The issue that the ICJ addresses, which is relevant for present purposes, is the extent to which the United States owed an obligation, pursuant to Common Article 1, not to take certain steps with respect to the Contras in relation to this conflict, of which it's not in itself party. So if you read paragraph 219, it should be sidelined in the electronic.
No, actually, in my hard copy too.
So paragraph 219 to 220, you see the court referring there to the obligation of the United States under Article 1 of the Geneva Conventions. When the court is ready, if you turn over to page 1810, see paragraph 255 to 256, the court's application of that rule considers the United States production and dissemination of a psychological operations manual for the Contras, which, amongst other things, suggested that it might be a good idea to neutralise judges and government officials.
Which paragraph was that one?
Is it 255? Well, that's the summary of the operations manual. 256 is the relevant conclusion. The 256 that I invite the court to note, underline the relevant wording for the purposes of the claimant's case. The words likely or foreseeable. So at 255, the court's referring back to the obligations at 219 and 220, which is shown the court of Common Article 1. 256, the court's referring to those obligations as saying acts which commission will be unlawful, or the commission of acts which are contrary to international law, are likely or foreseeable, where the state committing those acts, that is the encouraging acts, not the acts which are the breaches of the current breaches of international law, have at the relevant time at least knowledge of allegations of breaches in the fields.
This was an advisory opinion?
No, these are contentious proceedings between Nicaragua and the United States.
In front of the ICJ?
ICJ, well, yes.
Yeah, thank you.
So that's where we see, this is the first time that the ICJ is dealing with Article 1. There are 4 other judgments that are referred to below, and I'm not going to refer the court to them now, but if I may take the court to the most recent of the ICJ's judgments, which touch on Article 1. This is another case involving Nicaragua, this time against Germany. That's at tab 47, page 1930. So this is another contentious case. It's an advisory opinion. Nicaragua applied for provisional measures against Germany on the basis that it alleged Germany breached its obligations under Common Article 1 and Article 1 of the Genocide Conventions, which are easy to prevent genocide, by transferring arms to Israel for use in the war in Gaza. If we look first at paragraph 15, this is Germany's position. It's the second point that Germany makes, which is relevant for my purposes. court to read that. It's relevant for two purposes. First, in fairness to the defendant, it was not in issue in that case. There was no dispute between Nicaragua and Germany as to whether Common Article 1 applied to the act of a state transferring arms to another. Germany accepted that it did. It's also significant that we can see that the position that Germany takes is that taken by the Claimant in these proceedings, which is that the obligation, insofar as arms transfers are concerned, is ultimately an obligation triggered by or concerned with risk. So what one is looking at is the extent of or existence of a risk that arms are going to be used in a manner that gives rise to serious violations of international law. It's not being said to be necessary for the court first to conclude definitively that they are or had been. In paragraph 23, we see the court's assessment. It deals compendiously with both Common Article 1 and Article 1 of the Genocide Convention, paragraph 23. In paragraph 24, the court reminds states of their obligations with respect to the transfer of arms. Again, it's using the language of risk. It's obligations relating to the transfer of arms to parties to an armed conflict in order to avoid the risk that such arms might be used to violate the above-mentioned conventions, the above-mentioned conventions being Genocide Convention and these Geneva Conventions. So I've taken the court to those authorities just to indicate, at least at a high level, where the claimant derives its case from, the proposition that it's inconsistent with Common Article 1 to transfer arms to a state where you have made the assessments that the Secretary of State made, irrespective of whether or not those assessments are correct as a matter of fact, and irrespective of the legal conclusion that one would apply to the factual assessment that the exporting state has made. And whether we're right or we are wrong on that contention is of course not a matter for the court. Today, the essential point, sufficient for the purpose of my argument, to make clear that it was no part of the claimant's case in relation to Common Article 1 that Israel was or had committed violations with respect to weapons that had been exported by the United Kingdom. We did not need to invite the court to make any conclusion to that effect. The case on Common Article 1 was based exclusively on the defendant's own assessments of the fact, and what this part of Ground 8 invited the court to do was, in essence, to draw out the conclusions, the legal conclusions, from the defendant's clear risk assessment. It did not invite the court to make any conclusions as to lawfulness. It did not even invite the court to make any findings of fact. It was not necessary for the court to say anything at all about what Israel had done. It was sufficient, or would have been sufficient on our case, for the court simply to have recorded in its judgment, the defendant has concluded X. As a consequence of those conclusions, Common Article 1 prohibits continued transfer of arms. I move then to the second rule, which is duty to prevent genocide under Article 1 of the Genocide Convention. The claimant's case below was that the F-35 carve-out was inconsistent with the United Kingdom's obligations under Article 1 of the Genocide Convention. It was not that the court could find, or should find, that the United Kingdom was responsible, as a matter of international law, for breaching that duty by reason of the continued exports.
Sorry, can you just say that last submission again?
It's a distinction between inconsistent with and in breach of, essentially. Our case was, and we'll come on to why that distinction matters in a moment, our case was the United Kingdom is acting inconsistently with the duty to prevent genocide. We did not need to advance, we say, the further proposition, which is that the court can or should find that the United Kingdom is responsible for a breach of the duty to prevent genocide.
Thank you.
2 points about that. So consistency, the language of consistency is central to our case because that is the language of both the criteria that was being applied, that we say for the purpose of this ground as being applied. Criterion 1 talks of consistency with the United Kingdom's obligations. It's also the language of the self-direction that we rely upon, so it's the language that the Secretary of State used when making the F-35 carve-out. The Secretary of State said this is consistent with the United Kingdom's obligations. It may seem pedantic, perhaps, one order wondering as to the distinction to begin with, but that distinction between consistent with and in breach of was central to the dispute between the parties, and to explain why, I think it's necessary, for me to take the court to the Bosnia genocide case, which is a case that both sides relied upon below as an authoritative statement of the law with regard to the duty to prevent. This is tab 42 of the authorities bundle. It starts at page 1817. It's the case before the ICJ concerned, amongst other things, the massacre in Srebrenica. The relevant passage, for present purposes, is paragraph 430, which starts at page 1835. It's a long passage. Could I ask the court please to read paragraph 430 and 431? There are 4 points that I would draw out from those passages. The first is that the duty to prevent genocide is a duty of conduct and not result. The second is that the duty is engaged whenever a state knows or ought to know a serious risk of genocide. Third is that the duty requires a state, once engaged, it requires a state to employ all means reasonably available to it so as to prevent genocide so far as possible. That's the standard of conduct that the duty imposes when engaged. And the fourth point is that although the duty arises and is engaged and imposes that standard, from the moment that the serious risk threshold is engaged or met, the state will not be held responsible for breaching the duty unless and until a genocide actually occurs. And the defendant relies on the fourth of those points to say that if the defendant wants to succeed on an argument that the F-35 carve-out is inconsistent with the duty to prevent, it must satisfy the court that genocide is happening. For it to satisfy the court that genocide is happening, the court must make a conclusion that Israel is responsible for genocide. So that's the argument put by the defendant. Our answer to that is to say the court does not need to make any such finding because it is possible for a person to act inconsistently with the duty, which is a conduct duty, without incurring responsibility or, to use more familiar common law language, a liability for its breach. We say that that's right as a matter of general principle, there are numerous common law torts which impose duties of conduct, but which do not attach a liability for a mere failure to meet the requisite standard. Some contingent event, generally damages, is required before the tort will be complete, before someone would have breached the duty in a manner that gives rise to any responsibility to any third party. So negligence is perhaps the most obvious example of that. To use the example that was used below, I would undoubtedly act inconsistently with my duty of care to road users if I was to drive down the road with my eyes closed, but I would not incur a liability to any other road user until I actually crashed into one and caused damage. So that is correct as a matter of principle, we say, is apparent from that analogy and basic one reasons through the way that our law works. But international law, we say, recognises a similar bifurcation. And we can see this in very
Right,
general...
international law recognises
that bifurcation between the possibility of acting inconsistently with the duty, with the duty that imposes a standard of conduct, yet not being responsible for its breach. We see that in the International Law Commission's Articles of State Responsibility, which is in the Authorities Bundle at tab 52. I'll just take the court to one passage, and that, if I may. The relevant passage, my lord, is 1993.
Thank you. And these are the ILC draft.
The IRC's draft articles of state responsibility on that. If I could ask the court, because these weren't in the pre-reading, if I could just ask the court, please, to read points 8 and 9.
Sorry, I was making note to myself. I've got left behind. Where are we? Where's
Maybe-
the articles of state responsibility?
No, yes, page 1993, please.
Tab?
The passage.
Tab?
It's tab 52.
Thank you very much.
You want us to look at paragraph 8?
And 9, my lady, please. The key passage is in 9, but 8 is also relevant. Short circuit, perhaps, I mean, the key passage is paragraph 9. I'll read out the sentence. It is sometimes said that international responsibility is not engaged by conduct of the state in disregard of its obligations unless some further element exists, in particular damage to another state. But whether such elements are required depends on the content of the primary obligation. There is no general rule in this respect. So our submission is that mirrors really our common law. There are some duties that are essentially strict liability and others which are not. And we say that on a proper analysis of the ICJ's judgment in Bosnia genocide and the passages that I invited the court to read moments ago, that is how the duty to prevent genocide works. The duty is engaged and requires conduct of the state before a genocide takes place. If it were otherwise, the duty would be OTOs. If you only have a duty to prevent genocide when a genocide is happening, the whole thing is pointless. But the ICJ has interpreted the duty as being one to which it is only appropriate to attach a responsibility to third parties, so a responsibility to compensate, etc., in circumstances where a genocide actually occurs, so where the damage that the duty is intended to prevent actually occurs.
But the trigger, you say, is the engagement of the duty is the point when the state knows or ought to know that there's a serious risk of genocide.
Precisely.
So that's a fact find, isn't it? That's a point that needs to be established.
Serious risk needs to be established.
Knows or ought to know that there's a serious risk of genocide.
No, that's right. So it's absolutely right that it would be necessary for the court to conclude that the serious risk threshold was met. I'll come in a moment in my submissions to how the claimant put its case on that, and why it is that it would be possible for the court to make a conclusion that the United Kingdom knew or ought to have known that the serious risk threshold was engaged, without the court having to make itself any findings, but certainly any definite conclusion of unlawfulness by Israel. If I may just to conclude this point, so our case below is that the defendant had elided this distinction that I'm now drawing between inconsistency with and breach of. And I'll just give the court the reference, I don't want to take up time going to it, but the reference for that in the amended statement of facts and grounds, paragraphs 224 to 225, page 517 of the core bundle. You can see it in the
517?
page 517, really. You can see it in the aptly named long skeleton, paragraph 258. So, I don't invite the court to take that up now, but that's where the court can see that that is, in fact, how it's put in writing, certainly how it's put orally. That's, again, unnecessary for me to persuade the court that we're right on any of that. Simply sufficient that that demonstrates that one can come to a conclusion that the United Kingdom is acting inconsistently with the duty to prevent genocide without needing to make a finding that Israel is committing genocide in Gaza. On the serious risk point that Lady Justice Whipple raises, is absolutely right that it would be necessary for the court to accept that the serious risk threshold is engaged. 2 points
It means
on that.
the court would have to look at the actions of Israel and make findings about the actions of Israel, wouldn't it?
With respect, no, my lady. So the first point is, for the purpose of this submission is, even if that were right, my lady, that wouldn't amount to any finding of lawfulness or unlawfulness. This is the point that learned from Ms. Kaufman alluded to earlier. For an active state is concerned with the court being asked to adjudicate on the lawfulness of conduct. As my friends pointed out, there are numerous cases where the court make factual findings, very serious factual findings in relation to torture and other things in relation to third states. So point one in response. Point two is it doesn't even go so far as requiring the court to make any findings or determinations, because we say, and said below, that the ICJ's provisional measures orders, on a proper analysis and proper understanding, and on a proper analysis and understanding of the defendant's own risk assessments, that is sufficient. So essentially the court can look at what the ICJ has found and said.
But that was very controversial, wasn't it?
There was controversy about it, my lady, certainly. We said that the
ICJ?
well, the correct understanding, so the submissions that were made below, is that the ICJ did not make a provisional measures order on the basis of something other than a serious risk of genocide. That was the very basic way of putting it. The ICJ did not make a provisional measures order on something, on a trivial risk, on a proper understanding. As I said, I don't need to persuade and don't, I think, have time to attempt to persuade the court of this now. It takes some time to develop this submission, looking through the ICJ, the two cases, but also looking at the threshold for provisional measures in ICJ cases. It's akin to American cyanamide. It's a very low threshold. But for present purposes, our case below was it's sufficient for the court to look at the ICJ, sufficient for the court to look at the defendant's factual assessments, and that the court could and should conclude on the basis of that material without being required to make any findings of its own, other than that the ICJ said this, or the defendant has in his assessment of X date said this. The court would need to make any further findings. So those are my points on serious risk. And for me, I said earlier, there are my second headline under this topic, under this ground, is the alternative case. That alternative case looms, I think, quite large in relation to serious risks. I'll come back to that. But just finishing the first set of submissions in relation to the rules that were relied upon below, which are maintained now, the third set of rules, unless there are any further questions on the duty to prevent. The third
Can I just ask you something on Article 9 and your submission on the Nicaragua case? So your case is that although there is some uncertainty in international law about whether you need damage, you don't in any genocide or potential genocide case, is that right?
My submission is that there is no general rule as to whether damage is or is not required. One has to look at the specific rule, and that on a correct analysis and understanding of the ICJ's judgment in Bosnia genocide, damage isn't of course the right word. It's I think too weak a word to use to refer to genocide. But what I'd used earlier was a contingent event. So there's a breach of liability, and there's some contingent event that has to occur in the world before breach is going to be established. The contingent event that has to occur for the duty to prevent genocide is a genocide.
Thank you.
The third set of rules that I hope I can take at a faster pace. So, if it points out correctly, then I'm taking rather long with this, but Article 6 and 7.
You trespassing on his.
That's true. Article 6 and 7 of the Arms Trade Treaty invite the court to read them. We say it's apparent on the face of the provisions that they are risk-based. And I think it's also apparent from the judgment and the account that the judgment gives of the Arms Trade Treaty that the arguments that the claimant was advancing were arguments based on risk. If I may leave it there. Article 6.2 is parasitic. There are 3 points that were run. Article 6.2 parasitic. Article 6.3 is not. Article 7 is not. Article 6.3 and 7, though, in any event, are risk-based. So that's the submission in relation to the ATT. Very briefly on the alternative case. So the primary case below is the one I've just outlined. The United Kingdom, the Secretary of State misunderstood relevant rules of international law. Had he correctly understood those rules, we also had tentatively, but the Divisional Court ruled against us on that. We don't have permission to appeal, so I'm stuck with correctness. So our case had the rules been understood correctly. The only conclusion was inconsistent with. There was an alternative case, a much less ambitious case that was advanced, which is that there are misdirections, and the Secretary of State cannot show that it's highly likely that had he correctly applied his mind to the relevant rules, that he would have come to the same conclusion. So that, of course, is sufficient. That's right. That's sufficient on ordinary public law grounds to quashing of the decision. So that was the alternative case, and I think it's self-evident that that alternative case would not and did not require the court to make any conclusion about the lawfulness of the United Kingdom's conduct or Israel's conduct. It just required the court to look at the reasoning set out in the relevant decision documents or advice documents that the Secretary of State was given as to what Common Article 1 required, for example, decide whether or not that was right or wrong, and then look at the evidence and decide whether or not he's discharged his burden, showing highly likely that he gets the same result. So the objection from the court, this isn't just relevant to ground 5, it's relevant to ground 1 generally. The court's basis for refusing to determine ground 8 attaches only to the primary case. It doesn't attach to that alternative case. The alternative case isn't really addressed at all. So that's what I said about that. Final point, very briefly, footnote 10 of the judgment. This is referred to in paragraph 122. So this is I don't think it's necessary for the court to take this up. I can summarise it. But paragraph 122, the court says, so at the heart of the case that Israel has committed these breaches. See footnote 10. Footnote 10 is a reference back to paragraphs 12 to 14 of our skeleton and submissions that were made at the very beginning of the hearing. So just 2 very quick points to be made about that. The passages of the wrong skeleton that are referred to in footnote 10. Look at this. So let me give you the paragraph page reference rather. It's fact footnote 11, it's my fault. So page 72. Apologies for that. Page 72.
Yep.
Footnote 11.
As Claimant puts it at paragraph 14, 16.
Maybe yes.
Paragraph 56 of last skeleton.
2 very quick points. The passages that are cited there weren't passages of the skeleton or oral submissions that went to or related to ground 8 at all. They're passages of the background and or submissions that were made.
So in what context? I mean, were they part of the skeleton argument?
Well, yes, they absolutely were. But so the skeleton has headings, as they all do: background, ground 8, paragraph 12. The simple point is the actual content of our argument in relation to ground 8 these paragraphs do not feature there, the points made do not feature there. They were made by way of background context. It's apparent and clear that the divisional court found that those submissions by way of background context to be unhelpful, to be a distraction. We can be criticised for that, but what can't happen is the court take paragraphs of the skeleton that it thinks are unhelpful and distracting and say this actually represents the heart of the case, the case that was put. The analysis that the court was required to undertake is the analysis required by A, the section of the paragraph dealing with ground 8, B, the oral submissions of counsel that dealt with those paragraphs which are not cited here.
This isn't an error of law. The most you can say is it's an odd observation, but at paragraph 62, all they're recording your submission, but it's irrelevant whether genocide has actually occurred, which is the submission you've just made to us.
But correct. The reason I've taken you to this footnote is simply because it's cited at paragraph 122, which is the relevant bit of the judgment that Ground 5 is seeking to appeal. That's all right. I don't think I need to take up any more time. That in and of itself was not an error of law. It would be and is an error of law to the extent that the divisional court has said. We can see that it was central to the claimant's case, and the claimant's case did require us to make findings in X, Y, and Z because of these paragraphs of the skeleton. That would be correct. My needs, my lord, those are my submissions in relation to ground 5, unless there are further questions from the court on that.
Yeah, thank you very much.
There's one further aspect before I sit down. So there were 2 points in the next ground 2. So there's one aspect of ground 2 that I'll be dealing with, Mr. Steyn, and my friend will be dealing with the rest. The point on ground 2 follows from the submissions I've made, which is the finding or conclusions of the divisional court that Common Article 1 and Article 1 of the Genocide Convention are unclear, at least sufficiently unclear as to militate against them being received into the common law. That's the point on which I'll now address the court. If I may, I'll take the duty to prevent genocide first because it's the most straightforward. Now, the passage of the judgment dealing with this is paragraph 132, page 106 of the bundle.
132.
It's paragraph 132.
Thank you.
Page 106. The court see that on the division court's analysis, two aspects of the rule that are said to be unclear. The first, the extent to which one state is required by the duty to prevent to take action, and secondly, what action will be required. With respect to the division court, we say that that's mistaken. The first point is addressed in the Bosnia genocide case that the court's been taken, and the second is not a question of the content of the rule, but rather its application. So that's the first point. So maybe worth just going back to the Bosnia genocide case. The paragraph 430 tab 42. It's page 1835. 1835.
Thank you.
It's the first half of that paragraph, really, what the GT requires, the action that the GT requires a state to take. All means reasonably available to them so as to prevent genocide as far as possible. Goes on, all measures to prevent genocide which were within its power, which might have contributed to preventing the genocide. Now that's clearly understood as being the requirement of the rule. So, if I may, and to make that good, the next tab, so tab 43. These contain the United Kingdom's submissions in another case before the ICJ, relating to the duties under the Genocide Convention of Ukraine and Russia. If we look at paragraphs 53, those submissions, which are on page 1859. first sentence, we can see that the rule is sufficiently understood to enable the United Kingdom to make submissions to the ICJ as to what it is. And with respect to defendants and unknown friends, that's the submission that was made below by the defendant as well. So the defendant's submission, I think, what in the long skirt, and I'll give you a reference, but I think it's really contentious, was that generally accepted that's what the rule requires. So the extent to which a state is required to take duty is set out by the ICJ. Now, the divisional court's concern really is, so what does that mean in a given case? Of course, it may well be difficult. In fact, it may always be difficult in a case involving genocide for the court seized of the issue to determine whether or not a duty has been breached. But that, of course, is just a commonplace difficulty in any system of law. It's axiomatic that the fact that a law is not required to and would never be expected to dictate the application in all eventualities. So with respect to the divisional court, we say this is just an elision of a requirement of clarity of the rule. Fine. With requiring that the rule can be applied, that the application of the rule will be straightforward in all contexts and circumstances, which says no part of the law, either as to whether or not the rule is actually a customary international rule or whether it can be received. In relation to Common Article 1, the Divisional Court's analysis is the preceding paragraph. It's paragraph 131 of the judgment. The Divisional Court makes the point there that there is debate about the scope of the duty to ensure respect, and the Divisional Court is absolutely right about that. There is debate about the scope and extent of that duty, particularly when it applies. We make 2 points about the Divisional Court's analysis of paragraph 131. The first is that the debate that the Divisional Court is there alluding to is a debate which commentators refer to as the debate about the external dimension of Common Article 1. Positive duties that article imposes on states to take steps to ensure that parties to conflict who are outside of the state's jurisdiction comply with their obligations under international humanitarian law. But that debate goes to only part of the case that's advanced under Common Article 1. I've shown you by reference to the amended statement of facts and grounds. There was a case on the respect limb, I'll sort of return to this, and the ensure respect limb. And that's important because the decision that's under challenge here is the F-35 carve-out is not a decision that relates to a failure by the United Kingdom to take some step outside of its jurisdiction with regard to Israel or any other state. It is a decision taken by somebody in London with respect to weapons in the United Kingdom, which concerns the question whether or not weapons in the United Kingdom will be sent outside. And even the academic commentators relied upon by the defendant agreed that negative duties imposed by Common Article 1 could require a state to refrain or abstain from taking certain steps with respect to states outside of its jurisdiction. I'll just give the reference, but not take the court to it for time. The commentator I'm referring to there is referring to Robson, relied upon by the defendant below. She has a very interesting article on the debate about the extent of the external duty, but in the course of her article, it's authorities, tab 58. The relevant passage starts at page 2124 for the court's notes. There's an acknowledgement by reference to the Nicaragua case that Common Article 1 can impose obligations on states to refrain from taking certain steps in relation to a third party. If I may take the court to one authority, this is the ICRC's commentaries, to show you one paragraph of that. The paragraph is 115, page 2083.
Sorry, tab. Are we back in the authorities?
We are, my lady. Tab 57, please. This is is under the heading negative obligations. In paragraph 115, we see the RTRC saying an illustration of the negative obligation is a duty to refrain from transferring arms. So
Sorry, I know you're trying to go rapidly, but you've lost me now.
I'm sorry, my lady. It should be
I'm in.
tab 57.
Yep, I've got there.
The relevant heading is at page 2082, negative obligations. So my lady can see that what we're referring to here are the negative obligations imposed by Common Article 1.
I have it, thank you.
Paragraph invite relationship to read is 195, which is the ICRC. Now, of course, this is, we say authoritative, it's not dispositive, but we rely on this. And the ICRC is giving there as an example of the sort of thing that would engage the negative duty, about which we say there's not really any debate, arms transfers. Now, if I may, in 60 seconds, summarise what make the rest of the submission. So the second submission, I said I had 2 points. The second submission is, in relation to the external aspect, there is a debate. Fundamentally, what we say is we're right and the defendant is wrong. No, nothing more than that. I can't make that submission now. So we don't need to for the purposes of getting permission. If we're right on ground 1, the court will have to grapple with the requirements of Common Article 1 on the correctness standard. So the court will have to determine who's right and who's wrong about the scope of the external duty if that arises. Unless I can assist the court further. Great.
No, I'm missing the same.
Oh, sorry.
No, take it.
My ladies, my lord, I'm going to address you on the remaining parts of our grounds 1 and 2. So ground 1 foothold, judgment 110 to 118, our skeleton 13 to 25. First reason at judgment 112, Ms. Kaufman has addressed. I just want to say something on that issue as on the statutory and policy background. I want to make 5 points, if I may. 1, the statutory framework is designed to facilitate the Secretary of State's compliance with the UK's international obligations. The statute is set out at judgment 17 for your note. It is clear from sections 5.2 and sections 9.3 to 9.4 that Parliament has empowered the Secretary of State to impose export controls for the purposes of giving effect to the UK's international obligations, and moreover has required the Secretary of State to introduce guidance which identifies the consideration to be given to international humanitarian law and international human rights law in relation to the exercise of that power. Now, we don't say that the Secretary has to give consideration, qua the statute, to international law, but he has to turn his mind to the relevance of breaches of international law and human rights to the operation of the licensing regime, and moreover to provide a public answer in a form of statutory guidance to be laid before and scrutinised by Parliament. That is very clear from sections 5.2, 9.3 and 9.4 of the statute. See judgment at 17. That's the second point I wanted to make. Third point, it's in this context that the SELC were expressly adopted as one of the means by which the government had sought to implement the UK's international legal commitments and obligations. The fourth point is that Parliament was obviously aware that issues of foreign relations, national security, defence, and international peace and security may arise. Yet there is no hint that the guidance, the statutorily required guidance, should not be justiciable, nor round 2, that CIL rules shouldn't operate in this, it shouldn't be received in this field. And we see that.
Sorry to interrupt. Nor your second point?
Nor that CIL rules shouldn't be received. The main reason why the court said on our ground 2 CIL shouldn't be received is because of the context. We point to the statute. It's obvious from the context that these concerns are going to be live. But moreover, the table in paragraph 3 to the schedule to the 2002 Act expressly lists, we see a hint of this, judgment 17. The references, please don't take it up, but please just note it. Authorities 1, tab 1, page 18, it expressly lists as relevant consequences which enable export controls to be imposed, quote, national security of the UK and other countries, quote, regional stability and internal conflict, quote, breaches of international law and human rights, including, quote, the carrying out anywhere in the world of acts threatening international peace and security. So everything that the court relied upon, which Ms. Kaufman has addressed you on, that the court founded its non-justiciability conclusion on, is there in the statute in express terms. No hint that the court should take that it's non-justiciable, no-go area for the court. Nothing shall not be questioned, nothing like that. The fifth point I wanted to make is that the words in the statute relating to the relevance of international law are very wide. That is important, so I'll just do it very quickly, because it's to the debate between the consistency of international law and breaches of international law. If you look at 9.4a, you'll see the wide words. If you look at the table, I gave you the reference to it, you'll see also very wide words. 9.4, I think I said A, sorry, 9.4b, issues relating to any possible consequences of the activity. That's judgment 16, page 58. Any possible consequences of the activity. The schedule is summarised at judgment 17. If you please look at it in due course, you'll see that the relevant consequences defined as having an adverse effect, direct or indirect, of a kind that's then listed. So those are wide words. So those are my 5 points on the statutory and policy background. I'm now going to turn to the second reason why the court held that there wasn't a foothold. That's judgment 113 to 114. It basically said 3 things there, the court. 1, the carve-out was a specific measure in a specific case as contemplated in the guidance itself. 2, it said that the distinction between departing from criterion 2C alone and departing from the entirety of the guidance, including, in particular, criterion 1, respect for international obligations, it said that was unrealistic. And the third thing it said is that the Secretary of State had been invited to depart from the SCLC, and that indeed is the effect of what he did. We say these are essentially legal questions, but even if they involve any finding of fact, the divisional court was plainly wrong. And why do I say that? 6 points. The first point. 6 points. First point. The reference in the SCLC to the application to specific cases of specific measures is simply a statement of the general public law principle that a decision maker is entitled to depart from their policy where there's good reason to do so. Policies are presumptive, indicative, not controlling. Compare the judgment at 112, where the court appears to recognise this. In other words, that provision in the policy is simply emphatic, and it's understandable given the statutory context. This is very formal context for policy making, You've got to lay it in Parliament, and Section 595, Judgment of 16, says that the Secretary shall have regard to the policy. So it's understandable that you'd have this provision, but the point is, the fundamental point is that all of that leaves completely unanswered what it was that the Secretary of State was departing from, criterion 2C or the guidance as a whole. My second point, the contemporaneous records are totally inconsistent with the idea that it was the entirety of the SELC that was being departed from. They make it clear that A, the suspension was on the basis of C2C, B, that the carve out from the suspension for F-35s was a departure from only C2C, and the Secretary of State thought he was complying with everything else. And that's very clear. I invited you to read some of the material that we have in our skeleton at 22.2, the material at footnotes 9 to 10. Can I just give you two references in particular? The first is to a ministerial submission of the 24th of July 2024. That supplementary bundle, tab 4, page 76. That's a submission from the Export Control Joint Unit, ECJU, to the Foreign Secretary, recommending that the Foreign Secretary advise the Business and Trade Secretary to suspend extant licenses. The critical paragraph is paragraph 9, page 76. That says that licenses must continue to be compliant with all, underlined all, in the original, the criteria in the SELC to remain lawful. And that we don't assess any current licenses as being in violation of these criteria. That's page 76. I won't take you to Annex C, where you've got the review, details of the review. The second document, please can I refer you to, is the ministerial submission of the 30th of August. This is really important for reasons which will become apparent soon. 30th of August 2024, at Supplementary Model, tab 6, page 80. This is from Miss Rosemary Pratt. She gave evidence. I'll come on to her evidence in a moment. So Rosemary Pratt, she's the director of the Export Control and Sanctions Unit, and it's her submission to the Business and Trade Secretary. And paragraph 13, 8 to 9 confirmed that it is C2C that would be breached by the continued export, page 82. And page 83 at 13, critically, whilst this submission focuses on IHL criterion 2C, licenses must continue to be compliant with all the criteria in the SELC, the most relevant, C1. And then later on, ECJU don't address any licenses being in violation of these criteria, though this will be kept under review. And then the reason this is important is because if you go forward to page 85, at paragraphs 24 to 25, she does refer to departing from the SELC as a whole, and that is what the Divisional Court relied on in their critical para 114. At the second half of that, when they say, look at the invitation the minister was given, quoted at para 38 above, if you do a bit of detective work, go back to 38. 38, judgment 38, is this submission. It's the 30th of August submission. But we know that when she says, depart from the SELC, that has got to be read in the context of paragraph 13 of her submission, where she has said This submission focuses on 2C. Licenses must continue to be compliant with everything else. We assess they are. There is an irresistible inference that the advice was depart from 2C and not the entirety of the SELC. If we ask, where does the self-direction come from? The obvious answer is self-direction in the decision about compliance with international law obligations. The obvious answer is that it reflects the prior assessment of C1 compliance. The question the defendant, Secretary of State was invited to ask, and the question he answered was, is there good reason to depart from C to C? Not, is there a good reason for the guidance not being my policy in respect of this class of export? This is very important because it goes to foothold. It's the second reason the court gave why there isn't a foothold. They seem to be saying that because you've departed from one criteria, the policy vanishes totally in legal terms.
What about the proposition, which my reading of the judgment was, but it may be wrong,
Yes.
was that they departed from the policy so far as it was relevant to the F-35 carve-out?
Yes, that's exactly what they did. But what were they departing from? They were departing from criterion 2C, not any other criterion. The suspension was on the basis of criterion 2C, not any other criterion. And the carve-out from that suspension, it must follow, was from C to C. So the departure was from C to C. We can test it in the following way. Let us say that if next month the ceasefire doesn't hold and it's clear that the F-35 parts would breach international law and criterion 1, on the court's view, the SCLC has nothing to say about this. Secretary has decided to disapply all of it. But that amounts to a policy change, not a policy departure.
Just on that note,
Yeah.
you've taken us to the paragraph. What about 26 and 27?
Sorry, I'm just going to.
Sorry,
because
it
of
was
time.
the document you very helpfully taken
Yeah,
us to, the 30th of
Just
August.
because of the time, I actually haven't taken it up. So this is, I think, tab 6, isn't it?
Yes.
I'm afraid I'm all electronic, but
It's tab 6.
Page
86,
85
yeah.
to 6, yes. Sorry, my
And
lord.
paragraph 26, it was just
Yeah.
they identify the risk. In the meantime, UK components could be continue to be drawn from global hubs, could be used, including those belonging to Israel. You need to consider the balance between these two risks, and then you can reduce that risk by a specific act in 27. I mean, one way of reading it, which is obviously what the divisional court did, was that whatever is necessary to take out of SELC to decide that is what the
Yeah.
Secretary of State was doing.
Yeah, but please look at 13
Yeah.
on page 83. Licenses must continue to be compliant with the criteria. That's what we think is happening. We don't assess any licenses being in violation. You can't just sort of sever this and magic paragraph 13 away. The further point I'd make is after the redacted section, if you look at the question at page 87, do you agree, based on the Defence Secretary's advice, that there are good reasons to depart from the SLC? Well, that's general. The impact on international peace and security of suspending these imports overrides the IHL risk. IHL risk, that is C2C. It's not C1. C1 is international law. Genocide Convention. Genocide is not IHL because you don't need an international or non-international armed conflict for there to be genocide. It is not IHL. It's an international obligation, for example, C1. They think there's nothing wrong with that. There's no breach of that. F-35 carve-out, they do not think breaches C1.
Thank you.
And indeed, the third point I was going to make, the third of my 6 points, is that the Secretary of State, if you look at his skeleton, does not claim that he departed from C1. I'll just give you 2 references, if I may. We've got Sir James's skeleton below. at tab 9, core bundle, just the references please if I may because of the time, page 371, paragraph 220.9. The September decision, quote, also took into account the analysis against other relevant criteria in the SELC and the assessment that current licenses were not inconsistent with the UK's international obligations and other commitments. That they're not claiming it. It's even more clear, and in their skeleton at 223.1, core bundle, page 372, quote, the F-35 carve-out was also premised on the basis that licenses were consistent with other criteria in the SELC. They're not saying, St James is not saying the SELC was disapplied. That's my third point. Look at the claim that was being made. It was never said that they were departing from C1. It's very clear that their case was, no, we're complying with C1. That is why you get the statement in the decision letter that this is consistent with international law. The fourth point I wanted to make is about evidence. There is a complete absence of evidence to support the view at which the court arrived. It would have been very easy for Sir James's clients to put in witness evidence to say we were departing from the entirety of the SELC. Indeed, the Secretary of State would have been required by candour to say, if that was the case, to explain his decision making. Miss Pratt, who was the author of that key min sub 30th of August, gave evidence, and she did not say that that is what happened. I've got Pratt 2 here. It's a critical statement. We don't need to give it to you. I don't think Sir James is going to contest that there was not a scintilla of this idea. In her statement, she explicitly addressed how and why a decision was made to exclude components used in F-35s. That's a quote. She did not say we were departing from the entirety of the SELC. The fifth point I wanted to make is the idea in the divisional court that the distinction between departing from C2C and everything is unrealistic. We resist that respectfully. It's very significant. You would need a different reason for departing from your duty to prevent genocide, C1, than you would from C2C, serious although the latter is. You can test it more generally as follows. See our skeleton at 22.1. Imagine the Home Secretary is detaining people. There's a flood in Wing A of the prison. So she's got to accommodate people 3 to a cell for a while in Wing B. That breaches one condition, condition 3, let us say, about detention conditions. But the Secretary of State continues to detain, and she claims there's good reason to do so in light of the flood. Could that justify treating as inoperative other parts of the policy which say that vulnerable people can't be detained with dangerous prisoners, or other conditions which deal with clean bedding and clothing, for example? Obviously it couldn't. A departure, we say, from one requirement in a policy does not entail or justify departure or disapplication of everything else. The rest policy doesn't thereby disappear as a norm that presumptively regulates the decision maker's powers. The sixth and final point I wanted to make is, if you think about the function of a policy, the function of a policy in public law is to regulate decision making, to promote transparency, consistency, predictability, a fortiori here, where the setting, this legislative setting, is highly formal. You've got to lay your policy before Parliament. Those imperatives apply with all the more force. Indeed, the Secretary of State said when he introduced the policy that His Majesty's government is, quote, this is Judgment 19, quote, committed to a robust and transparent regime. The court's approach to make the SELC disappear, as it were, in legal terms, because one criteria has been departed from, promotes neither transparency nor robustness, and certainly not both. The third reason the court gave for saying there wasn't a foothold is at judgment 116. It said a tenability approach was appropriate because the issues were contentious, the context was highly sensitive, and so on. We addressed this in our skeleton at 23 to 24. The court's approach was contrary to principle and precedent. There is no case where a policy implements unincorporated international law, where a court has adopted a tenability approach. You might ask, well, why is that? Why is there a difference between self-direction, launder, Kebeling, corner house on the one hand and policy on the other? The answer is, we would venture to suggest, is that the rule of law imperatives are very different across the two classes of case. But there's no case. As a matter of principle, we know modern public law, see, for example, lots of Supreme Court cases to this effect. I think I asked you to read one, Mandalia. This is Lord Wilson, Supreme Court. The reference is authorities 15, pages 497H to 498B. The search is for the proper interpretation of the policy. It is now clear that its interpretation is a matter of law, which the courts must therefore decide for itself. Previous suggestions that the court should adopt the Secretary of State's own interpretation of her immigration policies unless it's unreasonable are therefore inaccurate. Tenability is redolent of that approach, deprecated by Lord Wilson in Mandalia and many Supreme Court cases since and indeed before. SK Zimbabwe, Kambadzi, and then you've got Hemati and others. Basic stuff. EOG, my lord will be familiar with the ECAT case. The policy implements ECAT. You look at what ECAT means. You don't apply a tenability approach, and you don't apply it because the context is sensitive either. You defer in the application of the policy if you've got grounds to do so, constitutional grounds, institutional grounds. You don't just say, well, launder, Kebeling is gone because of corner house, will transpose that into a policy. Wrong in principle, no support whatsoever. That's ground one. Ground two, we say that this is reception, CIL reception into common law. We say the court erred in concluding that the CIL obligations upon which we rely now, just Common Article 1 and Geneva Convention Article 1, we're not relying on Article 6 responsibility, shouldn't be received in common law. This is the judgment at 123 to 139. Judgment at 130 identifies two critical issues. A, were the obligations CIL? B, would their reception be consistent with constitutional principle? Judgment at 131, the court was prepared to assume that they were, but they held they weren't received. Our skeleton at 29 to 33 identifies 5 errors. Those at our skeleton 30 to 33 been addressed in substance by my learned friends. I want to make the following 6 additional points. Some of them are quite slow.
Well, you're now on borrowed time, so you'll need to be
My lady,
speedy.
yes, I'm sorry, I'm going as quickly as I can.
Understood.
Yeah, but I'll shoot through. Got to leave time for Miss Kaufman. Sorry.
Well,
I'll be as quick as I can.
have you cleared with Sir James that you're?
Well, Sir James is always very fast, but I mean, he wanted to see how it went. I think it's, if I may say so, it's generous to have a 2-2 split with half an hour in, but there it is.
Yes.
We'll go as quickly as we can. I'm not going to be much longer. 6 points. First, we say judgment 131.
Don't go so fast that we can't keep up. You're very old.
Indeed. Not at all.
Number one.
But number one, the reasoning at judgment 131 appears confused. In our submission, there is no, quote, very demanding test for reception into the common law. And the very demanding test is for establishing whether the CIL norm exists in the first place. And once it's established, the test for reception is not demanding. Indeed, there is a presumption that a CIL norm will be taken to shape the common law and recede, absent, quote, some positive reason of constitutional principle that it should not be. That's the Freedom Justice Party case, cited in the judgment at 125, para 117. Later in that case, the way Lady Justice Alden put it, as she then was the question was whether some principle, quote, overrides the presumption. That's 134 page in your bundle. Are you all electronic, can I ask? No. So it's, I'm hard copy as well. So it's Authorities 2, tab 20, page 1049D for 134. So presumptive reception, it's part of the ratio of FJP. I don't need to make that good, and if you want, there's Supreme Court dicta to that effect as well. Presumptive reception. And the reason why we have presumptive reception, unlike generally the position with unincorporated international law, the reason we have it is because CIL rules have a generally, quote, generally beneficent character. That's the Law Debenture Trust case at paragraph 204, Authorities 2/31, para 204, page 1555. It's quoted in the judgment at 128. CIL rules are very hard to establish. The executive can't simply create a CIL rule with the agreement of the state. One fundamental reason for dualism. We see that FJP 117, Freedom Justice Party. The third reason, the policy of the common law is that it should be in alignment with CIL rules applicable. So, presumptive reception. Second point I wanted to make is that some of the court's reasoning at 127, judgment 127 and 135, confuses with respect to the issues that were engaged in this case. This case, of course, is not about, quote, the disposition of the armed forces or the making of war. Ms. Kaufman's addressed you why there wasn't a no-go area in this case. If I may be forgiven, amidst the clash of arms, the law is, of course, not silent. Modern-day equivalent to Lord Atkin, the Campbell case that Ms. Kaufman referred you to, Mr. Justice Chamberlain, paragraphs 44 and 46, she referred you to those. That's Authorities 3.
Can I just ask about, I mean, I understand in relation to components that end up in Israel, but in relation to components which still need to be made and put into the global pool, isn't that exactly disposition of armed forces?
No, it's not. It's not the making.
Because?
Well, it's the supply of, it's defence, it's international relations, but it's the supply of advanced weaponry to a global pool.
On which those in the armed forces depend for security in Iraq, for example.
You're not sending them out anywhere. The cases are about the making of war, the disposition of armed forces. We don't for a second suggest that the issues aren't national security, defence, foreign relations, international peace and security. That's enough. But what you can't say is take a step further than that and say, well, we'll start making of war or sending our armed.
No, I mean, apparently not making war, but disposition of forces was all I was asking about. Yeah.
Never claimed. It's just a scratch. We resist it. It's not what they say is engaged by. The third point we make is that the CIL rules are rules of international law that, of course, operate between states. They're apt to have some bearing on matters of defence, peace, security, foreign relations. If you consider the cases on immunity, state immunity, Freedom Justice Party concerned special mission immunity as a defence to a criminal allegation. That obviously bears on foreign relations. What if a close ally wished the UK to prosecute a member of a special mission? Pinochet, immunity for former heads of state. Spanish request for extradition. Foreign relations, not a reason not to receive the rule. The fourth point I wanted to make is by reference to the statutory context. I've already made the submission. I'm not going to repeat it. The fifth point is that there is a hint in the judgment at 133 that because Parliament has legislated in the area in the form of the Genocide Act 1957 and the International Criminal Court Act 2001, because it's legislated, that suggests that the rules aren't clear. And indeed below, Sir James submitted that the reception of the CIL norms would interfere with parliamentary choices in relevant areas. That's not the correct approach. The question is whether the legislative code has, quote, effectively preempted the whole area, or, quote, where the Parliament has purported to create an exclusive code, or rather, where the reception runs with the grain of the legislation and legislative policy in the field. References to those quotes are KU, para 151, Lord Mance, Authorities 1, tab 16, page 558, letter H, and Freedom and Justice Party at paragraphs 125 and 126, Authorities 2, tab 20, pages 1047C and F. The criminal statutes to which the judgment at 133 refers do not address the preventative duties which we contend should be received. Why is it the case that you need preemption exclusive code? It's because of the doctrine of presumptive reception, not enough to decline to receive a CIL, nor to say that Parliament has said something about the rule at some point. That would be to reverse the presumption. And the last point I wanted to make is that if the rules aren't received, it would be open to the Secretary of State to depart from the criteria in breach of international law and customary international law. If the Secretary was allowed to do that, that would put the UK in breach of its own CIL obligations. And we know from the Supreme Court in Lord Bencher Trust, we know that the case for reception is, quote, all the more compelling where, quote, a failure to give effect to the rule results in the UK being in breach of its international obligations. That's Lord Bencher Trust, Authorities 2, tab 31, at page 205, paragraph 205, sorry, page 1555E. Finally, you will be aware, my ladies, my lord, of the extraordinary normative force of the CIL norms in issue here. On any view, the rules for which we contend here are, quote, inherent and fundamental to democratic, civilised society, end quote, in Lord Cook's words. In Daly, Lord Millett in Pinochet described genocide and torture together as among the many, as the most serious crimes against humanity. Lord Hoffman observed in the Belmarsh No. 2 case that amongst the many unlawful practices of state officials, torture and genocide are regarded with particular revulsion. Same is true of the basic rules of international humanitarian law and Common Article 1. Distinction, proportionality, protection of civilians, detainees reflect elementary principles of morality which have long informed the development of common law. See our skeleton below, page 262, Core Bundle, Volume 1, Tab 8, Para 301. In short, we say there was a fundamental moral imperative, the most extraordinary and extreme moral imperative there could be to recognise the CIL norms here, and the court erred in not doing so. Those are my submissions. I'm sorry I've gone over slightly.
Let's go back to you.
So, my lady, I just want, before I do anything, is just to address your which way forward would be best for the court. I can either address you now, and I'm going to have very, very little time. So this is on the 5230.
Yes.
Or we could complete the permission application. My suspicion will be that Sir James will be quicker than he necessarily thinks. And that might leave us a little bit more time then at the end of that to deal with this, because if I go now, I'm going to have a very, very short time.
How long do you think you'll be with your
Well,
reconsideration
I
submissions?
think I can probably do it in about 20 minutes or so, but at the moment, Sir James has said I can have about 10.
No, well,
My lady, listen, I'm not going to
Sir
quibble
James,
over
you may
minutes.
want to limber up for 10 minutes before the short adjournment.
I'm not planning on doing too much
Perhaps you could do some stretches.
I'm not planning on doing too much
Well, having
limbering
a
up.
sandwich.
Yes.
We'll leave Miss Kaufman to have the 20 minutes.
My concern is I'd much rather have this opened now
Yes.
and then me replying. So I would suspect it's much more
which is-
convenient. Even my learned friend goes till 1 o'clock.
Yeah,
I'm not gonna
which-
try and ditch over that.
Yeah, which is why I prefer to do that. So you have till 1 o'clock.
I have till 1 o'clock.
Thank you.
Right. Well, I shall.
Don't forget, we have read all the
You've read
papers
it
and
all.
we've read your scattergun.
Yes, I understand that. I do want to start though with a little background about firstly what the rationality challenge was, and then just to remind the court about the procedural background, because it is all very important.
Yes.
So the ground 3 challenge, the rationality challenge, was a process rationality challenge, and it was founded upon the argument that the process the Secretary of State had adopted had prevented him from weighing the competing considerations that needed to be balanced in order to determine whether there was good reason to depart. So on the one side of the balance, he had placed the damage that would be done to the UK's international relations, defence interests, national security interests, international security, if the parts going into the F-35 programme were suspended. And critically, he had actually calibrated risks in relation to that. On the other side of the balance, he had simply put in his assessment, which was made in relation to the application of the SCLC and paragraph 2C, that there was a clear risk of a serious violation of IHL. Now it's important, so the argument, and we don't need to concern ourselves at the moment with why the claimants argued it, but the claimants argued that a rational process required the defendant to actually calibrate further the nature, extent, quality of the risk in relation to the potential violations of IHL should he carve out the F-35 parts. The exercise the Secretary of State had undertaken in the application of paragraph 2C of the SCLC, that is the assessment of whether or not there was a clear risk of a serious violation of IHL in order to determine whether he should suspend, was one that he conducted using a particular methodology. And the methodology he adopted involved applying that same methodology that he had taken and had been applied, or a predecessor had taken and applied, in respect of the conflict in Yemen when considering whether or not to export arms to Saudi Arabia. That approach was one where, in looking at past conduct of hostilities, which is obviously relevant when one is trying to then assess the future risk of a violation of IHL in that self-same conduct of hostilities. In trying to look at that past conduct of hostilities, the Secretary of State looked on it on a case-by-case basis. Now, if you look at it on a case-by-case basis, you are dependent on all the evidence you can gather in relation to a particular incident. That worked in Saudi. It was a different conflict with different considerations, different cooperation from Saudi Arabia and so forth. He adopted that same approach in Israel and unsurprisingly came across difficulties in making assessments on a case-by-case basis. Those difficulties arising from the fact that nobody could get into Gaza, from the fact that Israel was not providing the United Kingdom with any information about its individual strikes. So the UK simply didn't have the information to evaluate on a case-by-case basis. Result, it didn't do so, save in a tiny proportion of cases. So when it made the assessment that nonetheless, despite those difficulties, there was a clear risk of a violation of IHL in the future, it wasn't because of the way in which Israel had conducted itself in the past in the conduct of hostilities. It was because it was able to make assessments in relation to a different aspect of IHL, which was relevant to the conflict, namely how Israel was treating detainees and how it was complying with its humanitarian obligations. So that was the starting point. And when the judicial review was mounted and when the grounds were amended in August of last year, before the carve-out decision was taken, the claimants challenged that methodology and that approach on the basis that it was unlawful and it was preventing the Secretary of State from properly looking at the past conduct of hostilities. Then we had, and that was grounds 2 to 5 of the ASFG, and they raised multiple different challenges that flow from that fundamental error of approach as the claimant submitted. Then we moved to the September decision, carve out, so suspension, then carve out, and the matter came before Mr. Justice Chamberlain eventually, when there had been toing and froing between the parties about how the grounds should be reformulated. And what Mr. Justice Chamberlain had to address was the claimant's argument that those grounds 2 to 5 should be retained in and of themselves, backward looking at the past decisions, because it was argued that the past decisions, albeit academic, remained important for future assessments, and this was an ongoing war situation. Secondly, and importantly for our purposes, grounds 2 to 5 remained relevant in relation to the rationality challenge, because it was the methodology adopted which prevented, in part, a more calibrated assessment of the nature and the extent of the future risks, because the Secretary of State had gone wrong in looking at and assessing the past conduct of hostilities. So they were all intimately connected. What happened at the hearing and in advance of the hearing through the defendant's amended grounds of defence was that the defendant said, no, don't worry. We don't need to look at methodology. Yes, there were difficulties in the assessment of risk, but it doesn't matter, because irrespective of whether there were any methodological errors, we reached the decision we did on grounds that do not, or on a basis that does not depend upon the method we adopted to justify the approach we took, i.e. no calibration was necessary, not because of the difficulties of the method, but because no calibration was necessary for other reasons. And that is absolutely clear from the judgment of Mr. Justice Chamberlain that you have had an opportunity to read. So we can look at paragraph 15 of that judgment. That's in, I've been working from the the supporting documents for the Part 5230 application, but I'm not sure what the court is working from, because it's also in the supplementary bundle. But
I'm
if we
just
can
using
take-
paragraph numbers.
Yes, so
for
paragraph
that.
15, which if you are working from the supporting documents for the 5230 application, is at page 29, I believe. Let me myself try and get that out.
Yeah.
It is
The
29, yes.
CCO bundle.
It's the,
10.
no, not the CCO bundle, absolutely. No,
Sorry, 29 of the other one.
it's the 52, it's the 5230 supporting documents
Thank you.
application, and it's 415 is at page 29 of that bundle. And if I can ask the court to read paragraph 7,
Yeah.
cited from the defendant's grounds of resistance. And then paragraph 16, see, paragraph 16, there is a mention in A in B rather of the difficulties of calibration. But if you move on to C, you will see that those difficulties do not bear upon the justification for the failure to calibrate. What is made absolutely clear is there is no need further to finesse or calibrate that clear risk, even leaving aside difficulties in trying to do so. So it is made absolutely clear those difficulties play no part whatsoever. Then at paragraph 17, Mr. Justice Chamberlain cites paragraph 19. No need to resolve. And then if you can turn to paragraph 31. Citing paragraph 140 of the grounds of resistance, and if you could read that. This element of risk would not have weighed more heavily in the balance, even if the defendant had adopted a different approach to the analysis of Israel's conduct of hostilities. And even if that different approach had led him to reach a different conclusion on risk, it could not have been clearer, and it was abundantly clear to Mr. Justice Chamberlain that methodology, the difficulties it presented, did not feature in the defendant's defence. Even though they'd expressed and identified that difficulty, it was not part of the justification for the method. And we see his decision on linkage at paragraphs 44 to 47. The court can just quickly read that.
Certainly.
And then the next development is when we get the skeleton argument of the defendant. And paragraph 220, this bundle, page 624, tab 10,
Sorry, supplementary bundle.
this same bundle that we've just been looking at.
We're in a different bundle.
Yeah, we're in the other
Okay,
one.
now we need to go to the supporting bundle. It's tab 10. Page
Yeah, it's,
624.
Sorry, just a moment. Okay.
What are we looking at here?
We're looking at paragraph 220, page 624.
Of
Of the defendant's long skeleton argument for the rolled up hearing. Paragraph 220 starts, the circumstances and premises on which the September decision was based demonstrate that no such calibration was necessary or appropriate. And then C, 3 rather. The difficulties in reaching conclusive IHL judgments reflect the realities of the fog of war, the lack of access to Gaza, including international media, the complexities arising from the sheer amount of information, misinformation, the context of the conflict in which Hamas is embedded, etc. So we have precisely that which it had disavowed relying upon as justification being deployed here. And we wrote straight away, that's at tab 11, you don't need to turn it up. And then we can see, and I'm not going to take the court to it, but the court's judgment, the divisional court's judgment at paragraph 185 of its decision, took into account those very difficulties as a reason why the process was rational. And they said in terms, it was a careful process. Now, by saying it was a careful process, the court is effectively endorsing the legality of that process and then relying upon it as a basis for saying that the decision, the process adopted was rational. So if we can turn then quickly to...
Sorry, maybe I'm misunderstanding. In Mr. Justice Chamberlain said that it's now clear that no calibration exercise is necessary.
No. Our cases, a calibration exercise was necessary.
Absolutely. And he said,
He said what is unnecessary to resolve in the claimant's case that a calibration exercise was necessary, and the defendant's defence to that was the question of whether or not the defendant's methodology was unlawful. That's what we don't have to consider at all. We're going to look at whether a calibration was necessary or not, irrespective of the method that was adopted, because as the defendant said, the method we adopted would have had no bearing upon the assessment we made, and the calibration was not dependent upon that. So that's the critical point, and hence we were prevented from making any arguments that one calibration was necessary and what had led the defendant to fail to calibrate was the method. So it was all out of play. And then the defendant brought it back into play, relied upon it, and the divisional court itself relied upon it. So there is a fundamental error and a fundamental injustice and unfairness that has happened as a result of the divisional court's judgment. Now, it's not the case that we didn't argue it. We did argue it. So that was all put before the divisional court. It doesn't appear in the judgment. So when...
I think you said it was 187, Catherine.
Oh, it's 185. If I said 187, I meant 185 is where the decision is. It was a careful and thorough process. So we've got to then look very, very quickly at Lady Justice Andrews' decision. Make 4 points in the paragraph where she says there was no unfairness. The first is that if we were dissatisfied with the judgment of Chamberlain, we should have appealed. But it's obvious. There was nothing for us to appeal. We were not dissatisfied with the judgment. The judgment was a finding on the basis of what the defendant had asserted that there was no need to argue the unlawful methodology point in order to determine the process rationality point. So there was nothing for us to argue. Neither side was going to be able to engage with methodology. So that is a fundamental error and a fundamental misunderstanding on her part as to what the linkage judgment and the linkage arguments were all about. The next point she made was that the defendant was entitled to describe the process adopted by, the court was entitled to describe the process adopted by the respondent as careful and thorough, given that there had been no finding that methodology was unlawful, and that was not an extant ground of challenge. I don't see a basis upon which the court could possibly have been justified in treating it as it were. Well, again, that fundamentally misses the point. What the court went on and did is to actually effectively decide the methodology point, decide that it was a lawful assessment, it was careful and thorough, when that was out of bounds for all the parties. Next, she found no material inconsistency between Mr. Justice Chamberlain's judgment and the position adopted by the defence before the divisional court. Well, I've shown the difference. In one, before Mr. Justice Chamberlain, yes, they adverted to the difficulties of the assessment of past conduct of hostilities, but they did not rely upon it. They expressly disavowed that as a justification for their process, the process they had adopted. So there was a fundamental inconsistency. And then, as to D, the Secretary of State confirmed that difficulty in assessing the reliability of the info. The Secretary of State confirmed that difficulty in assessing the reliability of information was a matter raised before Chamberlain. Well, yes, it was, but not on the same basis. It was an incidental fact, not a justification for the process adopted. The court has seen the authorities. We recognise it's a very strong test, but there is here an attempt to grapple with the issues, but a total failure to understand the fundamental nature of the issues that she was being presented with. the critical process that had gone before, and in our submission, that high threshold was met. It entirely corrupted this aspect of her determination of the permission to appeal application. And it has major implications. This is an important point, and the claimants, and the strength of it, we say, is overwhelming, such that this court should properly conclude that it would have made a difference. 1 o'clock.
Well, I'm very grateful to all three of you and all the team behind you, because I appreciate you have to fit in a huge amount in a very short period of time. So thank you very much indeed. So you can all have a breather now, and we'll reconvene. Thank you all.
We'll rise and able.